Every family thinks they'll never fight over real estate until they do. Today, we're talking about the one tool that can protect your family, your wealth, and your peace of mind, a trust. Hi, I'm Randy Ihara.
And I'm Dan Ihara.
And welcome to the Advisor Podcast. We are real estate wealth advisors here in Hawaii, and in today's episode, we'll be discussing trusts. Today's guest, we have Christina. Hi, Christina.
Hi.
Christina is a member of Yempuku Law and a key contributor to the firm's estate planning practice since 2020. She was promoted to a paralegal in 2021 and advanced to a senior paralegal in 2024. Prior to her current role, Christina served as the head of paralegal to attorney Stephen Yim, where she developed extensive experience in estate planning, client relations, and coordination of complex planning matters. Today, Christina leads the firm's public education initiatives, and serves as one of its primary voices in the community, focusing on increasing awareness and understanding of estate planning. She is dedicated to making the complex area of law accessible, practical, and meaningful for the Hawaii community. Welcome. Thanks for coming in today.
Yeah, thank you for having me.
So just to start off, for the people that don't know out there, what is a trust?
Yeah, so a lot of people come to us and they have different ideas in their head maybe of what a trust is. And there's really different levels of definitions. You've got your standard definition, which says a trust is a legal instrument where you have a trustee who manages assets that are held in the trust for the benefit of the beneficiary. I like to think of a trust as almost like its own entity. It's not, but I like to think of it as something that you can create that's almost like a third party. It's yours. It manages and it can own assets. So you can put your own assets in there that the trustee helps to manage for the benefit of the beneficiaries. The IRS defines it as a relationship between one party that manages assets that are titled for the benefit of another. And our firm, we really think of it like that as far as a relationship, that a trust is like its namesake. It's where you establish trust and you define relationships, really. A trust is an instrument, but we're defining relationships. We're defining the inside of our family. And by doing that, by defining relationships, this is who I want to leave my things to. This is who I want to manage the assets for my loved ones. By defining the inside relationships, we're thereby defining who's not a part of the inside, the outside relationships. Outside being like the court systems or attorneys, other attorneys, or ex-spouses, if you will. Those are the outside parties. And so by using a trust, we define those inside relationships, really. And we make it very clear of who's in the inside and who's to receive our assets. So,
yeah, that's a really cool kind of discernment, because I think a lot of us think of a trust as, like a bucket where you put assets in, but really kind of flipping it on its head and thinking of it as a way to build trust within the family, build relationships within the family.
Exactly.
And that's so cool to hear.
Yeah.
Why would somebody want to create one? Why do we recommend it?
Yeah, so there's so many reasons to create a trust. There's so many benefits. Most of the time people come to us because they hear that a trust allows them to avoid probate court. So I'll talk to what would happen if you didn't have a trust. So in the state of Hawaii, if you have assets without a beneficiary and you passed away without a trust, those assets would have to be cleared. They would go through the court systems, the probate court systems. The law has to have some kind of rhyme or reason and make sure that assets get passed to beneficiaries in a lawful way. And that's the court systems, the probate court systems. So what happens is, without a trust, and we're talking about assets of a combined worth of $100,000 or more. That's what the state says or states is substantial. So if you pass away with that amount, that value of assets or more, everything gets frozen first. All assets freeze. Then the courts appoint an executor or a personal representative. The personal representative has to then work with an attorney to file the proper court paperwork and move through the court systems to essentially clear these assets and get them to the rightful beneficiaries. One of the first things they have to do is make sure that the person that passed away didn't have any debt. Or if they did, that all debt gets paid off first. So there's a system. And what happens is a lot of times the court systems are a bit inundated. They're a bit backed up. And so this process of clearing assets can take a long time. Meanwhile, you're on retainer with an attorney. And so sometimes the process can last 3 to 5 years in this probate court. And so you're paying an attorney, assets are frozen, can't access anything. And what often happens is at the end, when everything is cleared, the assets are sort of in the estate are sort of drained, right? You had to maybe liquidate to just pay for attorney fees. So that's sort of the worst case scenario, but why people come to us in the first place is they want to avoid that. They want to avoid that court process, probate court, and a trust actually allows you to avoid it. If you set it up correctly and you connect your assets, you put your assets in there, you can bypass the court systems. So that's one benefit. Yeah. Probate is also public. Everything gets recorded. Everything that you own gets put out on paper and gets put out there. So, you know, it's a small island and everything
Don't want that.
Yeah.
Don't want that.
So that's another benefit to creating a trust is when you have a trust and you pass things to your beneficiaries through the trust, everything remains private. Nothing gets recorded when it's in a trust.
So pretty much anybody who owns real estate should have a trust. Oh, yes. And that property should be named in the name of the trust.
Correct. Exactly that. Because if the state's threshold for probate is $100,000, you know, there's no real estate under that, right?
Not
so
here.
Yeah. So that's one of the first indicators to why someone needs a trust is if they own real estate, yes. Or else it'll go through the probate court systems.
Makes sense.
Yeah.
Makes sense.
But beyond that, trusts are amazing. They're amazing tools. They're very flexible. You can write them however you want, and you can basically, you're able to maintain control. You can control how your assets go. Through the court systems, the state mandates how your assets get split up and distributed. For example, if you had a spouse, but you also had kids from a prior relationship, maybe they're not really in your life anymore. When assets go through the probate court system, those children are still rightful heirs to your assets, even though maybe you intended to leave everything to your spouse to provide for them for their life. The state, changes that or dictates something else, and so that's why a trust is, amazing.
When you say the state, you're really meaning a judge, though, right?
Correct. Yeah.
Exactly. A court process, and a human being a judge on behalf of the state is giving instructions to the world what to do with your wealth, but that may not be your wishes.
Yeah, right. And it's sort of they're not given maybe a lot of information, and they have to, rule on not being impartial and all that. So. Yeah.
So obviously we want to avoid a trust. Therefore, avoid probate. Therefore, we want to make sure all of our clients have a trust. And if you don't, let us know and we'll connect you so that you can start having the conversation around how do you build one and what do you want it to look like?
Yeah. And something else too that's really amazing about trusts is they offer protection. And for you as the individual maker, it provides protection from incapacity. Let's say you're the main breadwinner, or you are the main control of your assets. You pay the bills, you know where all the accounts are. You might wonder, well, what would happen if something happened to me? How would everything continue to function? Bills continue to get paid, right? So when you create a trust, you appoint a manager, a trustee, someone that you trust to basically carry the torch when you're still living, but maybe you have sudden onset, lost the ability to manage financially. You have it all set up in place already. So there's no lapse in, and you don't have to worry about periods of incapacity for yourself. The trust offers that protection. You have all your assets in there. You have already a backup manager set up. They step in, they continue to pay for your care and your health, as well as pay for all the bills and get everything done.
Yeah, and that point about incapacity, we never know when that's going to be,
Yeah,
right?
exactly.
And that just shows up one day. And if we're not prepared, it's kind of too late at that point, right?
That's correct. So these are legal documents that require you to be of sound mind to create them. So naturally, they are something that you create now for when you need it later. It's not something that you create now because you need it now. It's just the nature of them is you create them now for when you need them later. And that's required. Yeah. We do have a lot of people that contact us that, have come into a situation and now they're kind of in an emergency and they need legal documents, but unfortunately it could be too late. So you just don't want to wait till you actually need them to go to set them up.
Yeah, it sounds like when you don't have a trust, you're kind of just leaving all your assets, your family's well-being in the chance.
Right,
really.
exactly.
Right? There's no clear instructions. There's no clear definement of what's going to happen to the properties or assets or stocks. And the kids don't know what to do because there's no clear instructions for them either. And that kind of always leaves it up in the air where they could potentially fight over things that maybe could be prevented with a trust. Yeah,
exactly. And a trust is also amazing for your beneficiaries in that a trust provides protection, not only for you in periods of incapacity, but for your beneficiaries. You can use a trust to protect your children from creditors, predators, or ex-spouses. That's kind of our saying, creditors, predators, or ex-spouses. Okay. Because as we know, we work hard for our money and we want to, it's not that we have anything maybe against our children's spouses, but maybe we just intend for our money to stay in our bloodline and to be used for our family. And you just never know what could happen in the future. And so a trust, you can set them up to where it maintains that so that the money stays in your family and doesn't get lost to divorce, let's say.
Yeah. You work hard all your life and you've built up accumulative of wealth and you want to do what you want to do with your own wealth. You don't want to, let it slip away into some people that you don't want it to go to. You want it to go to the people you want it to go to.
Right.
Yeah.
Yeah. And then also, trusts are amazing because they can help with minimizing certain tax. It's another, common reason people come to us. You can't avoid tax, right? Taxes are inevitable. But we can actually use trusts and different tools to see how we can minimize some of that tax, which is amazing. Like tools like irrevocable trusts that essentially draw assets out of your taxable estate, thereby lowering your tax. So trusts are amazing.
Yeah, definitely are a great planning solution for those that have amassed wealth over time.
Right.
And for those of you who are out there that are in that position, start looking around for some advice that might be helpful for you and your family. Now, there's different types of trusts, right?
There are, right. Kind of alluded to that. So there's so many different types actually, but the common one that we work with are revocable trusts. We also hear and we use irrevocable trusts. But there's charitable remainder trusts, there's special needs trusts, there's all kinds out there.
What do you see most?
So we definitely set up revocable trusts most commonly.
Right.
Everybody needs a revocable trust. So we think about revocable trusts like maybe like the protein to your dinner meal. You got to have protein in your dinner meal, right? You got to have the meat there when you're sitting down to eat. So everyone needs that to start. From there, we can sort of add on or look at other strategies. And we may use irrevocable trusts such as irrevocable life insurance trusts. That's probably one of the second most common trusts that we utilize, maybe that. And we also work with a lot of special needs clients. And so we establish special needs trusts very, very frequently for our families.
That makes sense. That makes sense. Yeah. For us, we started our trust journey many, many years ago, and we've changed it over the years. And so what is the recommendation for people that, like, how often should they review that trust?
Yeah, so this is a really good question. I think a lot of times the assumption is create it one time, never look at it again. But that's kind of a little scary.
Yeah.
Laws change dramatically. The laws change. The state changes the law pretty frequently. And so you actually really want to pull it out and review it with an attorney probably every 3 to 5 years or so, we say.
Okay.
Is take a look, see if, also the other thing is life is fluid, life changes. You know, who we thought maybe we wanted as a backup manager 10 years ago, it might have changed. They might have passed away. They might be getting a little old themselves, right? So you always want to pull it out for yourself too and see if there's been any changes in your life. You've had kids or you've had grandkids now. Make sure that everyone's covered. So usually about every...
What if you did your trust a long time ago, and then the attorney that you used back in 1985 passed away?
Yeah.
Then what do we do then?
We do see that a lot. Now, you can go to any attorney at any point in your estate planning journey. You can see anybody, to whether it's an update or to create one for the first time, or even to administer a parent's trust that passed away. You can go to any estate planning attorney. The tricky part becomes if you don't have copies for some reason and the attorney has passed away, they retired. That's kind of a sticky point that we run into, right? So the good thing is to check in with an estate planning attorney as soon as you can. Now, if you made one a long time ago, you can't find it, your attorney's retired, they passed away, they don't have a copies, you can always make a new revocable trust. And so you want to do that before it's too late.
What happens to the old one though?
So the old one, essentially, if we wanted to, we can set up a new one and we can refund that new one or reconnect your assets from the old one to the new one. The old one then just sort of becomes empty. Don't need to worry about it. Nothing gets sent to it. All while you're living though.
Yeah. How do you know what the old trust says if you can't find it, or how do you are able to move it from the assets from one trust to another?
So as long as it's a revocable trust and you were the maker, you have total control. It's another beauty about revocable trust is you can move assets throughout your life. I mean, think about it. We're constantly accumulating assets, selling assets. So it's not frozen. A revocable trust is not frozen. You're not just stuck in that 1982 trust. You know, you have total control of your assets.
As long as you're
of sound mind, right? So
body.
Worst case scenario would be if you lost capacity, the old attorney didn't have anything, you can't make a new one now, right?
Now what?
Right. So oftentimes what happens is, we have to go to court, right? So if we don't have that original, we might have to petition the courts to like basically certify that old one to be.
We're in that situation now. We just found out yesterday.
Oh my goodness. Oh wow.
Incapacity and we're gonna have to go through the court process.
Another reason to check, make sure you have everything, you have originals, make sure it looks okay, and you don't need to maybe rely on your old attorney who may not be practicing anymore.
Now, are attorneys required to keep a copy?
They're not. So they used to be required. Yeah, we used to have like a period of time. I think we still do have a period of time where we have to keep electronic copies on file by law, something like maybe 3 to 7 years, something like that. But no, they're not anymore required to, to keep those.
Yeah, that's a problem. Don't lose your trust. Know exactly
Don't
where
rely.
they are.
Yeah, you have to be responsible to keep your own trust.
Yeah.
I heard you mention funding a trust. I think a lot of people who have a trust assume that their real estate or the assets will automatically be in the trust. But can you speak a little bit about that?
Yeah. So one another common misconception is, okay, I created a trust, I'm all set. But that's sort of step one or part one is creating this bucket, this trust. So first you create the thing, almost like an entity, right? You create it. The second thing you have to do is a trust doesn't automatically grab all of your assets. The trust just basically says anything that happens to be in here, do this with it. So like I said, we're constantly maybe buying real estate, selling real estate. And so the trust is just sitting, waiting to direct those assets, but it doesn't automatically own things. You actually have to physically change title or change the beneficiary of an asset to that trust. So when you first create a trust, it's unfunded, essentially. There's nothing really in it. Then the next step, part 2, is actually literally contacting your investment company, seeing if you can change title to your investments to be the revocable trust of John Smith. You have to actually physically change the title, the ownership of all of your items, either ownership or beneficiary, to be your trust. Same with real estate. You have to actually change the title on real estate to be the trust, record it with the state, and then that asset gets put into the trust.
Yeah,
So
many of our clients are not aware of that, right? People buy real estate, they buy it in their name because they're getting a loan, right? And they have to keep it in their name.
Yeah.
And then they forget. They pay off the loan and they forget to transfer it into the trust, assuming that the trust will automatically absorb it. And that's not true.
Yeah.
Right? And
Yeah.
so if you have real estate, take a look at it and see if it's in the name of the trust. And if it's not, let us know. We can probably help you get it into the form of the trust.
Yeah, we have many clients, right, that have real estate that did need to hold it a certain way, but we're able to work now with the companies to still have a mortgage, but still have the real piece of real estate in the trust. And so oftentimes even we'll purchase real estate in the trust. Maybe we'll refinance, our clients will refinance. So the refinance process requires it to be out of trust. So we'll pull it out, we'll refinance. And then as soon as that's complete, we put it right back in, and that, is sufficient. So
yeah, that's a big tip for today.
Yeah,
that could be a problem. Because what happens is we buy real estate, we forget about it, right? We just live in it.
Yeah.
And we enjoy it, but we don't think of how it's held in title.
Right.
And then something bad shows up and they go, oh no.
Yeah.
We get so many phone calls from folks that said, hey, Dan, I want to sell this property. And I look at, it's in the name of their parents, in their name, not in their trust. They said, well, if they had a trust, well, they didn't fund it. Now we're walking them through probate.
Yeah, exactly. So that's the difference between like an unfunded trust and a funded trust. And it's like I said, it's part 2. It's just as important as setting up the trust, is ensuring all of your assets, definitely real estate, is in that trust now.
Right. Makes sense.
Yeah. There's also revocable and irrevocable trust. Can you maybe share why would someone want to use an irrevocable trust?
Yeah, so they're a little bit different. By nature, a revocable trust is a trust that you could revoke, amend throughout your life. So you can create it, but you could take it back if you wanted. You can change it. You could put things in it. You can pull them out. Revocable trusts are very flexible. They're revocable. An irrevocable trust is a bit of the opposite. You can't revoke it, can't pull it back and say, never mind. You can't change it. It's essentially frozen the way that you write it. But there are some neat tools and neat things that we can do with irrevocable trusts. Because it's not changeable, if you put an asset into an irrevocable trust, like for example, real estate, you've essentially given that real estate away. You've given it away. It's no longer yours when you put it into an irrevocable trust. Using irrevocable trusts, let's say, you had a lot of wealth and you knew you didn't need that piece of real estate or that asset, you could essentially use irrevocable trusts to help your kids. You could use these irrevocable trusts to maybe give assets to your children in a controlled manner, not just outright in their hands. Here's some real estate, but we can use irrevocable trusts for the benefit of our children, but still teach them ways to be responsible. Like, for example, we have clients where there's an irrevocable trust. It has a good amount of money in it. So the child, it's managed by someone else other than the child. The child he's an adult child. He has a revocable trust of his own. He was able to actually borrow money from the irrevocable trust to purchase a piece of real estate. And now you have a situation where that child can still learn and practice how to be responsible, pay his mortgage, own real estate, allow the real estate to appreciate and grow, but you've protected the family wealth, and you haven't outright given them money, let's say. Yeah. So irrevocable trusts are really neat. Another thing, like I mentioned earlier, is the ability that when you put your assets into an irrevocable trust, you've given it away, it's no longer yours. Well, again, if you were in a taxable situation yourself where you were above the estate tax threshold and you're going to get taxed, your beneficiaries are going to get taxed, by moving your assets into an irrevocable trust, it draws that asset out. So it means it's no longer counted as part of your ownership, your taxable estate. It's no longer counted because you gave it away. So you can do that with life insurance. You can put life insurance in an irrevocable trust, still, reap the benefits of life insurance, where if you pass away, it goes to pay for, the care of your family or pay bills. But it's no longer counted as part of your taxable estate or your net worth. So it's an amazing tool, an irrevocable trust, to lower your taxable estate. Yeah.
Minimize the tax burden, estate tax burden.
Right. Yeah.
And then allow you to pass on more to your family.
Exactly. Yeah.
Yeah. And I think a lot of people, they think that they're never going to reach that estate tax level, right? But they don't realize that they're an asset that's growing in value. So now if they're 60, they might not be under it. In 20, 30 years, that asset's doubled, tripled. Yeah. Now they have a problem.
Yeah.
Right?
Yeah.
And the state of Hawaii's threshold is actually considerably low, 5.49 million, which you have a couple pieces of real estate, you're really close to that threshold. So it's more realistic for the state to bump up against that threshold than you may imagine.
Yeah, it's a smart move.
Yeah.
Once you've amassed wealth. Yeah, for certain.
So what are some of the biggest challenges that, you say your clients face on a daily basis?
Yeah. So one of the biggest challenges that we see from our clients that come in is, our whole goal becomes maintaining family unity. That's one of the biggest challenges. In this generation and in this wealth transfer that we're seeing right now, litigation or going to court and suing each other is at an all-time high. And so one of the biggest challenges is how do we maintain family unity, family harmony, especially if we have, for example, one piece of real property, one piece of real estate, and we've got multiple children, 3, 4 children. It's one of the biggest challenges is what do? We don't want to tie multiple beneficiaries to one piece of real estate. If we imagine what would happen leaving one piece of real estate to multiple children, first of all, now we've fractionalized this real estate 3 or 4 ways. And then let's say one of those children, maybe they had passed away, and so now their kids kind of get that piece or that share. And let's say there's 3 kids from that one child. So now you have 7 different parties that own one piece of real estate. So that becomes a challenge, that our clients face is, how do I maintain harmony? How do I ensure equal, or how do I make sure my children get what I feel is equal? And we have to sit down with them and devise a strategy or a plan to maintain harmony, maintain relationships, not set up one piece of real estate to multiple hands, but we set up tools. What can we do to ensure everyone kind of feels like they got their equal, I guess, inheritance?
Can you share maybe some examples or solutions that you provide to your clients that, can prevent family disputes, right? Because that's what we all want at the end of the day, for our kids to love each other.
Yeah, so there's a lot of great tools that we implement. So one of the first things that we'll do is we want to avoid disputes is we want to try our best to identify what potentially could cause a dispute. So things like one piece of real estate to multiple beneficiaries. We look at maybe if there are any senses of unfairness throughout their upbringing, and see how we can address that. For example, if one child lived at home the majority of their life, that could be something that could offset the fairness, let's say, between different siblings. So we want to first identify. We want to look and help our clients identify any source of potential for disputes. Then we want to help solve those issues. For real estate, what we can do is we can write into the trust something called the right of first refusal. And it's an amazing provision in a trust where it's sort of like guidelines, and it allows, let's say there is one piece of real estate, what do? We can write in some guidelines that say, okay, you children, you can buy each other out if you wanted to. You could sell this real estate if you wanted to. You could even co-own this piece of real estate, but you must agree. No matter what, you must agree. And we also, in that provision, we write in timelines. We write in deadlines, if you will, for this period. You can buy each other out, but you have to come up with, submit a price to the trustee within 90 days, let's say. And that helps to keep the guardrails on. It keeps the property moving. It doesn't get stuck for 5-10 years, let's say, with no one able to agree and come up with a solution. And so the right of first refusal is a really neat tool that we write in to ensure that we come up to a place where everyone feels good.
Yeah, when we first... because we saw many trust documents. I've looked at thousands of them, right? And almost all of them say, upon my demise, you three share it, right? And that's where the problem rises, right?
Yeah.
But your firm was the first firm that I understood that there is a solution, that if you put a time frame on that, those are instructions they have to abide by.
Right, exactly.
And so it's not a feeling, not an emotion, it's an instruction.
Yeah.
And I think clear instructions that your firm does that many don't do, I think is a magic sauce.
Yeah, exactly.
To keeping family together.
Right. And it can be even if you have multiple properties, but you're just not sure if they're going to agree and equally be like, I'll take that one and I'll take this one, right? You can put in the right of first refusal for all of those properties. And the other thing that we like to do is we do like to bring in a professional trustee. We think that, by having an unbiased third party to administer the trust and become trustee is one of the best ways to preserve relationships. That way we don't take one beneficiary and put them sort of above the others and kind of disrupt that. Everyone kind of stays on the same playing field, and you have one trustee that can, even enforce the right of first refusal or ensure that the property keeps moving.
Make sure that everyone follows the same rules.
Right, exactly.
That you wrote in your own trust. That makes a lot of sense.
Yeah.
I like the term that I learned from your firm, ho'oponopono.
Yeah.
Yeah?
Yeah.
Can you explain that a little?
Yeah. So ho'oponopono, really maintaining the relationships and keeping the relationships together and, keeping, the family unit together is so important. It's something we keep at the forefront when we sit down and, I don't know maybe what my ancestors might have done to you in the past, but we sit down together and we come to a place of ho'oponopono and please forgive what my ancestors might have did to your ancestors and let's come together and maintain our harmony.
That's so awesome.
Yeah.
Love that.
Can you maybe share a few stories or a story that you've helped walk a family through this transition, because it's such a difficult transition for a lot of families when there's so much wealth on the table that has to be divided, has to be distributed to the heirs.
Yeah.
Could you share a story for us?
Yeah. So one of the neat tools that we utilize in order to preserve relationships is something called family meetings. And we actually do it on the planning side. So we try to be very proactive. Yeah, we don't want to just hope for the best. So we really do our best to be proactive when we're still in the planning stages. So when you're still creating your trust or updating your trust, what we do is we hold these things called family meetings. So we bring everyone together, the maker of the trust, which in this case was a mom and her 2 children, her 2 sons. And in the trust, she had written that one son, his name was Daniel, was to receive the Manoa home. And she also had some cash and some other investments. And so she had Daniel to receive the Manoa home, and everything else was going to be split equally between Daniel and Aaron. So we saw that and we said, let's sit down, let's have a family meeting and let's talk about it. And so we did. Mom sat down with the sons and we went through what the trust had said, and we asked how everyone felt. And eventually we came to a place where Aaron spoke up, the one that wasn't receiving the Manoa home, and said, hey, I kind of feel like this feels a little unfair. And Mom was able to express how, she was surprised. Oh, I thought when we gave you the Rice Street house, years ago, that would have equalized, and he said he was able just to express how he actually never really intended on having that. And he took it because he was grateful, but, it wasn't really what he had wanted. And just by sitting down and having this conversation, Mom was surprised. And so they went back and they developed a plan together that worked. Yeah. So the 2 boys developed a neat plan where it felt fair, I guess, to them. Mom was happy. All Mom wants is for her boys to get along and not to fight. That's her only intention. It's not necessarily that you must have Manoa and you must have, this. And so they came back. We wrote it down in the trust, and Mom signed it. And so that was a really neat experience, just to see how this can work and how we can preserve relationships if we get together and we communicate about it.
Yeah. We're writing a book called Property Decisions.
Yeah.
And in that book, we talk about the most important tool is the conversation. It doesn't matter how smart people are, it's the emotion around things that happen at that time that make it either good or bad.
Right.
And so we can help with that. That's awesome.
Yeah.
Awesome.
I'm glad to hear that you guys are, in the community educating people on what's possible, how to prevent family disputes.
Mm-hmm.
That's so important to local families here in Hawaii.
Right. Yeah.
What's one takeaway that you've learned in your legal career that, you'd like to share with the audience?
Yeah, I think that it's really communication. It's really just that with everything that we do as a firm, these are just papers. They're just pieces of paper, and they help to be a starting place. But with every piece of the estate plan, whether it's the medical directive or the trust or the funding part of it, no matter what piece we're talking about, it's all about the communication, getting together, sitting down and talking about your wishes. And so, one thing that we've learned as a firm, and that we really try to, open our clients' eyes to, is how important it is to flip estate planning on its head. Trusts are not this secret, this top secret book that you put in the shelf and you hope no one finds it, and it's not this like bomb waiting to go off after your death. It's different. It's the opposite of that. A trust is meant to be something that we talk about, we talk with the family about, because if we feel like they might fight if they read it, then the chances are probably that they will, and when that time comes, and from what we've seen with experience, it's one of the worst scenarios. And so we really want to avoid that. And it's really common. And so that's really one takeaway is just talk together as a family. Talk about your wishes, whether it's end of life care and how you want that to go, and whether you want to be your life prolonged or not prolonged. Just talk about it.
Yeah.
So everyone
just
knows.
make it clear. Make your wishes clear.
Yeah, exactly.
Yeah. Well, thanks for tuning in to today's Advisor podcast. If you got value from today's conversation, be sure to check out our previous episodes to learn more about how we help families build, protect, and pass on wealth through real estate. We'll catch you in the next episode. Merry Christmas.
Merry Christmas.